Right, let's in fact now turn to the big focus story. In a significant verdict in the Gyanvapi case, the Varanasi District Court has upheld the maintainability of the plea by the Hindu side, which sought right to daily prayers and worship of the deities, claiming to be deities and idols inside the Gyanvapi premises. Rejecting the contention by the Muslim side, the court said that the Places of Worship Act is not applicable in this matter. The next hearing has been scheduled for 22nd of September. Let's take our viewers through the timeline of events, the important dates, just to jog our memory in this case. It started with 18th of April 2001, when petition was filed seeking permission for daily worship. In August 2021, the court sought responses from concerned authorities on this petition. April 2022 is when the court ordered a video survey of the complex. Now, this is where trouble began. The survey was conducted. On the 6th of May 2022, the Anjuman Intizamiya Masjid Committee opposed the survey. On the 14th of May, the survey resumed, and it continued, in fact, for 2 days. On the 16th of May this year, shivling was found during the survey. The AIMC, the Muslim side, in fact, contested the structure, said it was a fountainhead that was used for wuzu. It is not a shivling. On the 19th of May, the team submitted its report to the court in the Supreme Court. On the 20th of May is when the Supreme Court transferred the case to the Varanasi district judge, citing complexities and sensitivity in this case. In fact, on the 26th of May, the hearing began on the maintainability part of the case. 24th of August, Varanasi district judge reserved its order until today, the 12th of September. And today, like I mentioned, the verdict came in favor of maintaining the plea, admitting the plea. This was a plea to conduct prayers inside the Gyanvapi mosque on a daily basis. So that is overall in terms of the factual information on what happened in this case and the way things panned out. This has been a highly contentious issue. Remember, there's a huge deployment of security forces there in Varanasi to maintain law and order so that nothing untoward takes place between the communities. Let's listen in to some important reactions coming in.
न्यायालय ने इस सुनवाई को सुनने योग्य मानना है, इसका मैं स्वागत करता हूं और बाकी न्यायिक प्रक्रिया जैसे चलनी है वैसे चलती रहेगी, लेकिन सभी पक्षों से मैं यह जरूर अपील करूंगा कि इस फैसले का मैं भी स्वागत करता हूं, सब लोग स्वागत करें और किसी भी प्रकार से इस विषय को लेकर के कोई विवाद उत्पन्न करने का काम ना करें। यह एक बहुत साफ सुथरी न्यायिक प्रक्रिया के अंतर्गत जो न्यायालय के सामने विषय रखे गए हैं उसके आधार पर सुनवाई हुई है और सुनवाई के बाद यह सुनने योग्य है कि नहीं है इस विषय को लेकर के फैसला आया और फैसला आने के बाद सभी लोग इसका स्वागत कर रहे हैं, मैं भी स्वागत करता हूं।
ये जो आज ऑर्डर आया है, इससे देश में अब बहुत सी चीज़ें शुरू हो जाएंगी। हर कोई जाकर ये कहेगा कि नहीं नहीं, 15 अगस्त 1947 से पहले से हम यहाँ पर थे, तो फिर 1991 का जो प्लेसेस ऑफ रिलीजियस वर्शिप एक्ट है वो तो उसका मकसद ही फेल हो जाता है, क्योंकि 91 का एक्ट इसलिए बनाया गया था ताकि इस तरह के कॉन्फ्लिक्ट जो है वो हमेशा के लिए ख़त्म हो जाए। मगर आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज़ के ऊपर और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं फिर।
My colleague Madhav joins us to give us a perspective on what transpired in court today and how significant this verdict is. Madhav, good evening. Over to you. If you can take our viewers through the importance of the verdict that we heard today from the district court in Varanasi.
Well, it's very, very significant, Afrida. As you know, a number of things change after this verdict. The first and foremost is the Supreme Court itself, which had said that they would await for the district court's orders as far as this particular matter is concerned before they hear the matters pending before the apex court itself. So to that extent, it has an import over there, although the petitioners are expected to take this forward as far as the High Court is concerned and appeal over there. That is, of course, that is the Muslim side in this case, which has been the party whose pleas have not been heard. Remember, very significantly, the Muslim side had said that this should not be heard at all, and that the Places of Worship Act would prevent any such matter, any such plea from being heard, which would change the character or the religious character of this particular place of worship, which is completely banned under the Places of Worship Act 1991. But what was the plea of the petitioners, the four ladies who wanted to ensure regular prayers at the Mata Shringar Gauri temple, which is on the outside of the Gyanvapi mosque wall? Their plea is that this is something that was happening before 1993, before the Places of Worship Act came into effect on a regular basis. Its frequency was changed to once a year following that, and therefore there is no change as far as religious character is concerned. It is just a reverting to a practice that was there earlier that has now in fact been their plea, and that plea has now been found to be maintainable by the court. So what really this does is that we have seen political reactions from parties such as the MIM, Assuddin Owaisi, coming out to say that he fears that this will lead to multiple pleas in different places of worship that are disputed to come out, and for them to file such similar pleas in the court, which he says will now be seen as a precedent and will now be considered maintainable, whereas earlier under the Places of Worship Act this was not considered maintainable at all. There were of course several jurists who had viewed that with the existence of the Places of Worship Act no such petitions could be even entertained, but now that has changed with this district court's order. All eyes of course will be on what transpires in the High Court as far as the issue of maintainability is concerned, and eventually of course this matter would go up to the Supreme Court, given that it's such a closely contested issue. But certainly what has changed drastically is that the legal framework or the legal architecture that had been debated about for a long time, perhaps with this landmark order, in fact the entire aspect of those places of worship where there was some kind of issues in the past, all of that perhaps can be redressed legally speaking, or at least examined legally speaking, is perhaps the big takeaway from today's
Thanks,
judgment.
Madhav, which is why in fact we have experts on the show to help us understand the legal perspectives as well. Let me introduce joining us this evening Deshratan Nigam, a lawyer, Anirban Banerjee, also a lawyer, and Aditya Singh, an advocate. Thanks very much, gentlemen, for joining us here on the program. So, I was just taking a look at the number of contentious locations that we have in terms of places of worship. There is Tilewali Masjid in Lucknow. There is Rudra Mahalaya in Gujarat. There is Adina Mosque in West Bengal, Bhadrakali Temple in Ahmedabad. So where does it end? What is one to make of the spate of suits filed across the country? Court orders are directing entry into ancient mosques. Videography is being conducted by court commissioners. Searches are being done for religious artifacts or for symbolism, and claims for the right of one denomination to worship in the place of worship over another. So this pattern can simply continue, Deshratan Nigam. If we have decided now to admit a plea, it becomes a precedent, isn't it?
Well, in fact, every single incident or a case stands on its own footing. Not that this will be a precedent or that would be a precedent, because every structure has a different facts and circumstances, and if the matter goes to the court, they will be tested on parameters of law, facts, and evidence. So I will not compare this with any other case, whether it is Mathura, because Mathura is based on certain alleged lease and transfer of rights, which has been challenged. So here is a different case altogether. Ram Mandir was a different case. Based on archaeological evidences, the place was dug up and this thing was there. Initially, if you recall, Hindus had asked for only 3 places, but the Muslims didn't agree to it. Probably if they had, things would have died down and things would have been, but they stuck to their guns and let the court decide. And now the courts are deciding. They also believe in the court process. We also believe in the court process. And as and when the cases come and the disputes, whenever there is a dispute between 2 parties, when they don't agree on a particular issue, then the courts are the only place left where we can go for adjudication of our disputes. So this will continue, and I don't see an end to it. And the fact is, 1991 Act was brought very arbitrarily, not even mandatory 7 days were given in the parliament for discussion, no notice, and suddenly it was bulldozed. And arbitrarily, all others pending cases were, allowed to abate without going into any kind of research that was on how many cases are pending and how many cases have to be adjudicated. Suddenly, all the rights of people who believed in those places were taken away. Highly arbitrary with a modified intention, and that is under challenge in the court, Supreme Court, and Supreme Court will look into it. Both procedurally, the way it was passed, and substantially in terms of law, whether it is constitutionally valid or not. So far as this particular case is concerned, this is only about the maintainability of a petition. It is not about changing the religious character of a place. The puja was going on since time immemorial, and prior to 1947, and prior to 1991 Act also, and subsequent to 1991 Act, and after that it was restricted for a few days. And therefore, the religious character prior to 15th August 1947 was that the puja was going on. So prima facie, it does not change the religious character of a place, and that is what the court held. It also went into the other act of Waqf Act, saying that it is not applicable to non-Muslims or strangers, and therefore Waqf Act will not apply. Secondly, Kashi Vishwanath Temple Act, Management Act, which is there of 1983. It is prior to 1991, which declares the entire area as temple to be managed by a management committee. So that act has not yet been challenged by anybody, and I think it had gone for a challenge. It has been upheld.
But let me be clear, Mr. Nigam, that now at this stage, it's just that the plea has been admitted. It's just that the plea, the maintainability of the plea has been upheld. So it is no way a verdict in favor of one side or the other, if I understand it correctly.
Absolutely, absolutely.
Yes. Let me have Mr. Anirban Banerjee respond to what you said. Go ahead, Mr. Banerjee.
Yeah, first of all, I have very strong objection to the fact that we are calling the plaintiffs and the defendants of a civil suit as Hindu side and Muslim side. I mean, however much they might want, or even Mr. Nigam might want, but the plaintiffs do not represent the entire Hindu community, nor do the defendants represent the entire Muslim community. That is one.
I think for convenience of understanding, but I do agree with you. It's actually even uncomfortable for me, even as an anchor, to use words like this. Yes, go ahead.
Yeah, therefore, and the second part, as you said, that this is simply the order given after hearing the maintainability petition, whether even this is admissible to the court or not. In my opinion, this order is bad in law, because under the Places of Worship Act 1991, however it had been passed in the parliament, whatever the process was, whether you like it or not, that is a very different issue. But under that act, since it is an act of the land passed by the parliament, the court and the people, all of us, the citizens, we have to follow it. It is not about my personal preference or Mr. Nigam's personal preference. It has been challenged before the Supreme Court. The Supreme Court is yet to nullify the act. Therefore, the act stands.
But the petitioner's side argue that this is not applicable in this particular case. The Act of 1991 does not apply. How would you respond to that?
I understand that is their argument, but in my opinion, this is the very reason the act was brought in the first place, to avoid any kind of dispute with this religious undertone that could lead to communal tension in the future. That was the very purpose of the particular act. It is not simply a page consisting of a few words. It is the aims and objectives of a particular act. That is the most important part that has to be considered when the court, or maybe with the plaintiffs or the defendants, they are trying to put forth their argument. Therefore, the aims and objectives of the particular act was to avoid any kind of further conflict after the Babri Masjid demolition. That is the particular point of this act. Therefore, we are here not to go into the nitty-gritty states bits of whether it's Benares, whether it's Mathura, whether it's Malda or Ahmedabad, whatever. We have to avoid these kind of communal conflicts, and therefore the parliament had passed that act. The court should have followed that spirit of the parliament, and this order, in my opinion, is bad in law. But anyway, it is simply an order of the against the maintainability prayer. And the final verdict is, I think, is a very long way down.
Yes.
We do not know.
Let me have Mr. Aditya Singh also respond. Mr. Singh, to what extent do you agree that the law was brought in to avert precisely this situation, that there should not be communal disharmony, there should not be these kind of conflicts. So a date was set. So after that, it will be status quo. However, if you start challenging it, then there could be no end to it. And the worst part is, once the law and order situation gets disrupted, it affects us all. The amount of resources that would go into each of these cases, the country would be just embroiled into deciding and settling these disputes. Aditya Singh.
I can understand, because see, ultimately, what has happened in the past has happened. Today, like when we see World War II took place, millions of Jews died, there was a lot. But today, if you, try and open ghosts of the past, like people as a whole should realize. Now, when I come to the aspect of the CPC, the proceeding going on is essentially a suit. And in a suit, there is a plaint. Now, in the order which came out today, essentially the issue was maintainability, because from what I understand,
Yes.
the defendants had filed, had challenged the maintainability of the suit. And maintainability of a suit is challenged under Order 1, Rule 8 of the CPC. Because unless or until you show that the suit falls within scope of Order 1, Rule 8, the suit cannot be thrown out. Because every suit has to proceed to the stage of issues. Now what happens is, probably certain factors that should have weighed on the judge's mind were, because even the Supreme Court, Honorable Supreme Court had said that there are several issues involved. Now the point is, and one more thing, under the CPC, the Civil Procedure Code, one issue comes in is of, like mixed question of law and fact. So, like what happens is, whenever a preliminary issue tends to involve a mixed question of law and fact, not just a mixed question of law and fact,
Okay.
like whether the shivling was recovered or not, whether worship took place or not, and then if a shivling was allegedly recovered, then there'll be expert evidence, like the expert person. There might be expert archaeologists, range of experts who will be cross-examined. So one thing is clear is that the proceedings in the suit are likely to be protracted because of the complexity of the issues involved. As regards the religious aspect, I do believe that yes, what is history should remain history. There's no point repeating Babri once after again. The country has gone through a lot. Instead,
Yes.
both religions should reconcile. But finally, if I view this from the technicality, because the CPC is a very technical legislation, because every plaintiff has a right to institute a suit. And the only way a defendant can get a suit dismissed without framing of issues is by showing that it does not disclose a cause of action. But in this aspect of whether suit discloses, like for example, we have the Places of Worship Act. Now, the Places of Worship Act was not accompanied by a schedule of containing a list of worship places, isn't it? So obviously, then the language of the act is not in dispute, but then the court will go into the question whether did the religious character of Gyanvapi mosque include Hindu worshippers visiting? Did it contain some objects of significance there? Then then from CPC is very open to evidence. They say record your evidence, let the witnesses be examined, all expert evidence, Section 44 of Evidence Act, every aspect will be looked into by the judge. So I believe that the order of today should be looked at from the standpoint of the Code of Civil Procedure.
Okay, but when we talk about the Places of Worship Act, as far as the Act is concerned, it only deals with one principal question. What was the religious character of a place of worship on 15th of August 1947? The Act is not concerned with what existed before the construction of the place of worship, what materials were used to build it, whether it stands upon religious symbols or icons or artifacts of any religious denomination. All that matters is whether on that date, when India gained independence, it was a temple or a mosque or a gurudwara or a church or a monastery or any other place of worship. And it was held by the Supreme Court, if I'm not mistaken, that the purpose of the Act is not to correct historical wrongs, but to start with a clean slate at our independence. Why must we then, Mr. Nigam, go back to correct the wrongs of the past? And how far back can we really go?
The fact is, as I said, if initially the Muslim side, and again I'm showing as a symbolic, in terms of symbolism, I'm using the word Muslim side, had agreed initially for the three places that the Hindu side was claiming, I don't think things would have reached so far. But they were adamant because they were the birthplaces of the most worshipped, deities in India. But then they refused, and therefore, probably now an entire exercise has to be taken at the government level as to identify places which have had continuity of worship and which are very clear as to the places were demolished. And then, both the sides can sit on the negotiating table and work with pro quo, some kind of a thing. And the Hindus have always been very magnanimous, and I'm sure they will give up rights on many, many places. But there are some original places that we adhere to, we worship them. Something like, Makkah and Medina for Muslims, or Vatican or Bethlehem or Jerusalem for Christians. And therefore, you have to give equal importance to Hindus as well in the places that they find it very significant in their religion.
Okay.
And therefore, this is what to be understood by the other side. And these temples have not been built just like that. They have been identified. These are energy centers, and especially
but
the
Mr.
items have
Nigam,
been
now you want the
consecrated.
courts to settle these matters. The courts will have to settle it. So how far back can the courts go? It's not mutually being decided between the two sides, and the courts will certainly have to uphold the constitution, the law of the land. And if I remember correctly again, a senior BJP leader had said that finding of a shivling in the Gyanvapi mosques just settles it. It makes the restoration of puja imminent. So nothing can be done about it now, Mr. Banerjee. It seems that just the finding of the shivling itself has now already settled the matter for one side, that it does not come under, it will not now, the application of the Places of Worship Act. Does it really boils down to that now? Will it apply? What do you think, Mr. Banerjee?
Not be naive, we all know that this is not a simple civil suit that has been reinstated before the court. This is a highly political issue. This will be taken up, or rather this is part of the bigger plan. We have seen this for last many decades. We had certainly hoped that we had seen the end of it, but now we can see that no, there is no end in sight. At least for, I don't know, for the next 20 or 30 years, this is going to be the next Babri issue, I think, for our country to deal with. And the point is, whether there was a mandir under the mosque 100 or 200 years back or not, that is something we read in history. That is fine. I don't want to get into those details, who was right, who was wrong. But today itself, how does it really matter what happened 500 years back? And that is the exact spirit of the Places of Worship Act. We should have learned from our bloody experiences during the Babri days, where there were riot after riot, people lost their lives for what? And granting quote-unquote belief, this much of importance is a very problematic thing.
But Mr. Nigam is saying certain places are sacrosanct. You can't go there. Those places cannot become a matter of dispute even, because it is sacrosanct for one side. So, barring those places, maybe the rest of it can be settled or discussed, but not these few, which Mr. Nigam was mentioning.
Who decides that whether these places are numbered at 3, 30, 300, 3000? Who decides that? I mean, what is this Hindu side, Muslim side? I have nothing to do with these kind of disputes that might lead to bloody riots. I don't want anybody's lives to be lost just because of somebody's political beliefs. These are nothing but political beliefs. Okay. Because when you're granting quote-unquote belief this much of importance, see, there were many people in the past who used to believe that the Shoti Protha, burning the widow with her husband's corpse, is a very good thing to do. That was their belief. Now, if they want to bring back that tradition and challenge the fact that it is barred in our country, what would you say? If the court grants belief this much of importance, anybody will start claiming anything and say that this is my belief, you have to allow me.
Which is why this is such a complex issue, this is extremely complex, to the fact that Mr. Aditya is saying a court can settle, I understand, issues of title or trespass or possession, but can it adjudicate on, say, whether Babur actually invaded Ayodhya, destroyed a temple? Can the courts be made to go through that kind of evidence, to go back that far in history? Is the court expected to do that, like in a case like this?
Well, actually, the point is simple. There is, under the Evidence Act, we have the concept of judicial notice, where the court takes judicial notice of several facts. Even historically also, the court can take judicial notice. Because, remember, what is history? History is essentially circumstantial and anecdotal evidence. There is no concept of direct evidence under history. And most importantly, like if I take one instance, like people are saying that a shivling was discovered. But the point, my question is that was the shivling discovered during the course of an archaeological dig? Did the Archaeological Survey of India discover a shivling? Just, someone comes in and says ki ye shivling hai, so the defendant's side can actually raise several valid points here. Is that the so-called shivling was because this site obviously would have been explored by the Archaeological Survey of India several times back. So the point is that when the court weighs the evidence, what is history? History is the form of texts. Now the point is when there is a text, like by a reputed historian, the court of course will take judicial notice of the fact of those books. And it will take judicial notice of the, materials of the Archaeological Survey of India. Maybe they might even summon an expert from the ASI. And as regards the shivling issue, of course, because had the shivling been discovered had the so-called shivling object had been discovered in the course of an archaeological dig, then yes, the evidentiary value might have been greater. But then, the defendant side might say, no, it was there, it was like, there'll be a lot of...
So those submissions and arguments are yet to be made in a court of law. As of now, what we have is the court upholding the maintainability of the plea. Thank you, gentlemen, for joining us, for your clear perspectives on this subject matter. Thanks very much for giving us your time. We'll have to leave it at that, but of course, yes, it must be said that ultimately resources of the state will go into it. Court's precious time will go into it. Do we need a dispute of this nature when the country is grappling with much more?